movie would be, I've got a couple of them. I really enjoy The Hangover. Anytime it's on TV, I always watch it. I also like current war movies. 13 Hours was a great movie, and Lone Survivor was a great movie. Working at AGRUSS Law Firm is fast-paced. We are high volume. It is a healthy amount of stress. Every day is new, it's different. Constantly getting phone calls and emails, talking to clients. Working at AGRUSS Law Firm is collaborative. It is very open door. We all talk together throughout the day, whether we're discussing a potential case, whether we're discussing a current case, whether we are settling a case, whatever it may be, we're all actively involved, communicating with each other, and it is a good place to work. It's unlike any other law.
Quý vị đến với buổi talk show ngày hôm nay, trưa thứ tư với hãng luật AGRUSS Law Firm. Thì hôm nay chương trình tuần này có một sự góp mặt của một khách mời, đấy là anh luật sư Mark Galler, đại diện đến từ hãng luật Mark Galler Law tại Chicago. Thì hôm nay ấy, thì chủ đề ngày hôm nay chúng ta sẽ nói về những luật về hình sự, về dân sự, là criminal law. Thì trước hết thì chúng ta sẽ là cùng làm quen với những người khách mời hôm nay của chương trình. Hey guys, how are you today?
Pretty well, thanks. I appreciate you having me on today. Thank you very much.
Yeah, thanks for being here. Hey Mark, can you introduce a little bit about yourself? What do you do? How long you've been practicing law?
Absolutely. My name is Mark Galler. I'm the principal attorney and founder of Mark Galler Law, LLC, where we primarily focus on criminal defense. I've been practicing law for going on 7 years now, and the primary focus of Mark is anything from misdemeanors and traffic violations up to and including serious felonies, Class X, and anything in between.
Okay. All right. And what about you, Mark and Taylor?
Yeah, Mike AGRUSS at AGRUSS Law Firm. Thanks for having me on the show again.
Okay.
We handle personal injury and consumer rights cases. Been licensed for 17 years and have had my law firm for just over 9 years.
All right. Thanks.
And I'm Taylor KOSLA. I'm a partner at AGRUSS Law, and we handle consumer rights and personal injury. I have been an attorney there for 3.5 years.
Right. Awesome. Thanks all for your introductions. Thì thưa quý vị, hôm nay có mặt tại đây có 3 luật sư ở đây. Thứ nhất là anh Mark Galler, luật sư Mark Galler là chuyên về giải quyết những vấn đề luật dân sự, luật hình sự như là những cái vi phạm về giao thông này. Anh Mark thì đã thực hành luật trong vòng 7 năm và hiện đang có một hãng luật riêng của anh ấy là hãng luật Mark Galler Law Firm. Thì tiếp theo sau anh Mark là Mike và Taylor, thì chúng ta đã gặp trong những chương trình lần trước. Mike đã làm luật 12 năm và cũng có một hãng luật riêng, đấy là đồng hành cùng chương trình chúng ta ngày hôm nay là hãng luật AGRUSS Law Firm. Thì Taylor cũng là một đối tác partner của hãng luật có kinh nghiệm là 3,5 năm trong những vấn đề như là tai nạn giao thông, thương tích cá nhân. Rồi thì cá nhân của professional của 3 người luật sư đây, chúng ta hãy cùng đi vào những câu hỏi của chương trình ngày hôm nay. Rồi, right. So I think we can get started with our Q&A sessions.
Sounds good.
Yeah.
So Mark, why don't you tell everyone a little bit about what type of criminal law cases you handle?
Yeah, so range back to the beginning of our conversation, we at Mark Galler Law practice traffic violations, your standard speeding tickets, improper lane usage, DUI practice, and everything we do is on the defense side. So we represent individuals that are facing these charges up to misdemeanors. It could be simple battery, it could be an assault, it could be petty theft, and up to felonies, up to Class X felonies. So if there's aggravated circumstances for gun charges, drug cases, and sexual misconduct, we fight vigorously. We prepare the case and we work it up to trial, and if we have to go that route, we'll fight the case. That's what we're here for. Otherwise, we work out a deal hopefully with the state, and we work through mitigation and ultimately try to get the best ultimate outcome for the client.
Okay.
All right. Thanks for your answer, Mark. Luật sư Mike hỏi luật sư Mark ở đây là những cái vụ luật hình sự nào thì anh bên luật sư Mark làm việc. Thì luật sư đã trả lời là một trong những cái trọng tâm của hãng luật làm việc là về giao thông, như là lái xe khi mà say xỉn này, DUI, cái như là dùng thuốc này, hoặc là có chất kích thích mà trong khi lái xe, và cao hơn nữa là những cái tội nặng xâm phạm về tình dục và những cái hành vi mà trái pháp luật thì hãng luật của anh Mark cũng làm việc với. Right? Thì next my question for you, Mark. So walk me through the process of a criminal case from arrest to a trial.
Sure. So it depends on if the case is a misdemeanor or a felony. We could stick with felonies for purposes of an example to answer your question. And a felony starts with an investigation through a police agency where the detective will get involved, be tipped from either a victim or a witness to allegedly had occurred. The detective will investigate the matter, work up the case. If they think that there's enough evidence to find probable cause to arrest the individual, the suspect, they will go ahead and proceed with obtaining either an arrest warrant or trying to contact the suspect to bring them into a police station so that they can go through the arrest process of booking and then ultimately charging that individual. For felony purposes, because that's where you're facing minimum of jail time, potentially probation. It's something that the state's attorney or the government will get involved in ultimately to make a determination if there is probable cause, meaning if there's this objective circumstance that is out there saying, hey, it's more likely than not that this person committed a crime, so now we're going to protect society and we're going to bring the individual. If they make that determination, then they're going to bring this officer in who worked up the case, to present this evidence through testimony, kind of like how we're speaking, but under oath, in front of a grand jury, which is members of the community that are going to listen to this testimony, listen to the evidence, who ultimately make the determination if there's enough evidence to proceed, if there's probable cause to proceed with actually activating the case, where it gets assigned a number, and now you have to fight these charges. If the government decides not to go down that route through a grand jury, they can go through what's called a preliminary hearing. A preliminary hearing is what attorneys like to do and have afforded to the defendants, because that gives the attorneys an opportunity to question the officer under oath on the stand and really lock in their testimony, trying to get into their mind to see what they saw, why they're making these determinations, and what the officer's trying to do to make this arrest stand at the hearing so that it can push forward to an actual case. That doesn't usually happen. The standard's very, very low for the government to have a judge find. So once that happens, once probable cause is determined, then the case proceeds to what's called an arraignment. And each of these stages of the case are given dates, right? So say today we got arrested, then they'll have a date for a bond hearing. Okay, so that's the next step. The bond hearing is where you have an opportunity to get out of jail by either paying money, or if you're released on your own recognizance, they call it, where you don't have to pay any money, and you're given an I bond, which kind of holds it as security that you're going to show up to court. So you have the arrest, you have bond court, then you have the preliminary hearing, which we went through. The next step after that then is an arraignment, which is where you'll be brought in front of a judge, the accused, to be read your charges formally. Then you know, hey, this is the exact accusations against you and the charges that you are now facing. Then you're going to be assigned your permanent judge for the case. So they'll give you another date to then appear before that judge to do an arraignment, and then that is where you with the arraignment, you're letting the court know if you're pleading guilty or not guilty, and if you wish to proceed to fight the case and work through a discovery process, which is where you're collecting evidence, such as police reports, witness statements, any sort of video surveillance. They're working up the case. You're trying to get all the evidence possible to then proceed defending your client. Anywhere from a month to a few years, depending on the severity of the case, right? And most people, when they're dealing with this, it's either their first time or they don't understand that it could take a very long time, especially in a pandemic.
Yes.
So you work up the case as best you can to get all the evidence. Then you start fighting the case. Maybe you have a motion to suppress. Maybe you're going to argue that the officer shouldn't have stopped your client and ultimately they shouldn't be facing these DUI charges, right? So you can do that. And depending on the, you can either win at that stage of the case, or you can prevent certain evidence from coming in at trial. And then after that, you're heading towards trial. So that's the last final step. And there's a statistic of about 1% of all cases ever get to trial. So your chances of ever really having to sit in front of a jury or a judge to determine if you're guilty or not guilty is pretty slim, but it does happen.
Right. To be more specific about the bond hearing process, like it really depends on what type of criminal act, right? Something you can't just like bond your way out. Is that correct?
That's exactly correct.
Add more details?
Yeah, great question. It depends on the severity of the charges.
Right.
If you're facing a simple drug possession charge, say it's marijuana, illegal possession of marijuana, and it's your first offense, you've never been in trouble before, you've never been arrested, you've got a high school diploma, you've been a working individual, you've got a family, the judge is going to be more lenient.
Right.
If you're a repeat offender, you've got multiple drug cases, you've got multiple illegal possession of firearms cases on your background, then the judge might either set a really high bond, or say it's $100. If the judge sets a $100,000 bond, that's going to mean a few things. That's going to mean that you've got probably a pretty bad background, that the severity of the charges are pretty high, and then you're going to have to pay 10% of that, so $10,000 to actually get out of jail. It could be everything in between. There's mitigating circumstances that can help you afford a lower bond and essentially stay out of jail while you're fighting the case.
All right. Cool. Well, thanks for your answer. I will talk to our audience. That's a pretty...
Get it all?
Yeah, I hope. I will get the main ideas. Thì thưa quý vị, thì khi mà Thành hỏi anh luật sư Mark ở đây là cái quá trình mà mình đi một vụ kiện dân sự bắt đầu từ việc bị bắt giữ đến việc ra phiên tòa, thì quá trình đấy sẽ trải qua bao nhiêu giai đoạn. Thì cái bước thứ nhất là sẽ bị bắt. Cái bước thứ hai là sẽ đến là bond hearing. Bond hearing ở đây có nghĩa là quý vị có thể trả tiền cho về chính quyền để được miễn trừ cái không phải ngồi nhà tù nữa. Nhưng mà cái bond hearing một số cái đặc biệt ở đây là nó tùy vào mức độ của cái việc phạm tội. Có những cái tội nặng thì mình không thể nào mà dùng tiền để mà trả để được ra tại ngoại. Trong khi đấy, một cái ví dụ khác nữa là nếu như mà mình lặp lại cái vi phạm đấy nhiều lần và thậm chí là cái mức độ nó nghiêm trọng thì mình không được dùng tiền để mà tại ngoại. Thì sau cái quá trình bond hearing đấy là mình sẽ đến một quá trình là coi như là nghe tiền phán xét, là preliminary hearing. Thì trong cái quá trình này thì quý vị là sẽ được tòa đưa cho một người bồi thẩm, thì người ta sẽ nói chuyện với lại cảnh sát này, nói chuyện với lại thám tử này. Thì trong cái giai đoạn này luật sư, nếu như bạn có luật sư thì họ sẽ vào, họ sẽ nghe, họ sẽ chất vấn những người cảnh sát, những người mà bắt giữ bạn, xem là cái điều mà họ bắt đấy có đúng không. Chẳng hạn như là bạn tích trữ cần sa trong xe hơi này, hoặc là chạy xe DUI, chạy xe khi mà mình bị say xỉn, thì đấy là lúc mà luật sư sẽ vào cuộc để mà làm rõ cái tính pháp lý của những cái việc mà cảnh sát mà đang ấy với bạn. Và cái thời gian mà trung bình đấy trong một cái vụ hình sự thì thường là từ 1 tháng đến khoảng vài năm, phải mất vài năm, một vài phức tạp thì vài năm. Thêm một cái điểm mà đáng chú ý ở đây nữa là theo về tỷ lệ thì là chỉ là 1% những người bị bắt phải ra tòa, thì cho nên là cái tỷ lệ này khá thấp. Vì cái quá trình nó quá dài, thưa quý vị. Thì đấy là một cái quá trình của một vụ dân sự khi mà từ bị bắt đến khi mà ra tòa. Thì tiếp theo thì sẽ có những cái câu hỏi của Taylor cho luật sư Mark. Okay.
Mark, when you're pulled over for speeding, improper lane change, or a DUI, should you talk to the police?
My first instinct is always to say no, and it really depends on the circumstances. If you're facing an improper lane usage violation or speeding violation, and you've got a clean record, you don't have any prior moving violations, sure, be cordial with the officer, try to engage in conversation, see why they pulled you over, if you've got a reasonable explanation for why you might be speeding, because those types of cases are going to be very difficult to fight. They're going to either have the LiDAR, which is the radar gun that can detect the speed. Those are always calibrated, so you're not going to be able to fight against it. Now, if you're suggested, talk with an officer, see if maybe you can get away with the warning. But if it's something that's going to involve a DUI, or if you've possession of any sort of illegal narcotics or firearms in the vehicle. At that point, I would refuse to answer any questions. Again, be cordial. If they're asking for your name, what you're doing, I would give the name. Anything further than that, I would say respectfully, I decline to answer any questions. The more information you give, they're going to use against you.
You once gave me really good advice. If you're ever pulled over for DUI, instead of actually speaking with the officer, I should have a Mark Galler business card and just roll down the window a little bit, smell your breath, isn't that correct? And then pass
100%.
the business card. That was great advice that you gave me once.
Yeah, thanks. And if you're fortunate enough to have one of my cards, it explains your rights on the back, and you're correct. Hand that to the officer. The less that they have to use against you in court, the less evidence that they have, the greater your chances of being able to fight it and beat the case ultimately is at your favor.
I might have missed a little bit of the testing your breath. When they ask you to do so, do you have to, or can you decline? Can you say, "Oh, I talked to my lawyer first"? What is that like?
So you can decline. If you
Okay.
decline under the statute, under Illinois law, then that's an extension of your driving privileges. It's not permanent. It could be temporary, and there's a lot of factors that go into that. But to answer your question, you can decline, and you can decline and refuse any tests that they ask you to do. They can ask you to do, a one-leg stand where you stand on one leg and you have another leg up and you have to count, or if you have to do a walk and turn where they make you walk on a line and turn around and come back. You can refuse all of those tests, and you can refuse to answer any questions. Again, to Taylor's point, if you're talking to an officer and you had been drinking, they're going to say that you have an odor of alcohol in your breath. But if you don't talk, how can they say that? And I guarantee 9 out of 10 times the officers report. And then if they've got video footage, you use that against them, and that's how you start picking away at the government's case against you to beat it.
Okay. And I think the audience might have a question about if they give you some tests like, one leg walking and you decline, can they arrest you?
Absolutely. If they think that they have enough evidence, if there's enough probable influence of alcohol or drugs, sure, yeah, they can arrest you.
Okay. Thì thưa quý vị, hỏi luật sư Mark một câu hỏi là khi mà bị cảnh sát, khi mình đang chạy xe ấy, thì mình có nên nói chuyện với người ta không? Thì luật sư Mark đưa ra một cái ví dụ là mình không cần nói gì hết, mình có thể đưa cả business card của mình là luật riêng của mình cho họ, và mình kêu mình có thể từ chối trả lời những câu hỏi đấy. Nhưng mà bên cạnh đấy có một số cái việc như thế này, nghĩa là cảnh sát có thể kêu mình là test cái nồng độ cồn trong người. Cảnh sát mà thấy được nồng độ có thật sự có cồn ấy thì tất nhiên là sẽ có những cái biện pháp mà về pháp lý đến xảy ra đến quý vị. Nhưng mà ở đây có lại có một điểm đặc biệt là Thành hỏi luật sư Mark là nếu như mình từ chối luôn, mình không muốn cái test đấy thì sẽ như thế nào? Thì bạn được quyền từ chối, không phải test cái đấy, nhưng mà bù lại là nếu như cảnh sát mà có bằng chứng chứng tỏ là người bạn có mùi cồn, mà những cái test bằng một chân, nếu như có vấn đề thì họ vẫn có thể bắt bạn nếu như bạn từ chối cái bài kiểm tra về độ tỉnh táo đấy. Right? So Mark, another question for you. So I'm an immigrant, and there's like many in the country, who first language is not English. So in that case, like, what if you don't speak English and the police want to talk to you, and are the police required to get a translator?
If you're in custody and the police are seeking to interrogate you and question you, once you are in custody, then yes, they would have to provide you with an officer who is able to either translate or speak in the native tongue of the suspect.
Okay. What about before that? When they pull you and you speak English.
Sure, and there's a misconception with, and this is kind of leading back to the Miranda rights, where the police would have to inform a suspect of the right to remain silent, that they have the right to an attorney, anything they say can and will be used against them, and that provides a protection constitutionally under the Fifth Amendment of self-incrimination. You don't need to incriminate yourself. You don't need to give evidence to a government body that they can use against you and try to proceed in prosecuting you. So when people think that just because they're in custody they need the Miranda warnings, that's not true. If you're in custody and they're trying to interrogate you, it's a two-pronged factor. Then they would have to provide you with the interpreter or an officer that can speak in that native tongue. Otherwise, the officer, if they're questioning you and if you're not able to understand them, it's not going to go anywhere. Right. So that's why they would either call somebody in or they would have that officer meet at the police station who can then handle the questioning and the interrogation.
Okay, thanks for your answer. Thì thưa quý vị, Thành vừa hỏi luật sư Mark ở đây là trong cái trường hợp mà mình không nói được tiếng Anh ấy, mà mình bị bắt giữ lại ấy, thì phía bên luật sư họ có phải cần một người thông dịch viên hay không? Thì câu trả lời là có. Khi mà người ta bắt quý vị thì họ phải cung cấp một người nói được cái ngôn ngữ chính của quý vị để mà tiến hành cái quá trình bắt giữ và tạm giam. Thêm vào đấy nữa là quay lại cái câu hỏi về phía trước ấy, là khi mà bị bắt thì mình cần phải nói gì không? Tất nhiên là câu hỏi là không, quý vị không cần phải nói gì hết. Thì khi Mark nói đây là những cái gì quý vị nói ấy, có thể được dùng để mà chống lại quý vị ở phiên tòa, thì cách mà tốt nhất đó là mình nên dùng cái quyền thứ 5 của tu án chính là Fifth Amendment. Không cần phải nói, không cần phải trả lời câu hỏi của cảnh sát.
So while we're talking about Miranda warnings, what exactly, I've got a couple of questions. What exactly are Miranda warnings? And what's the difference in, or the distinction when someone says you have the right to remain silent and you also have a right to an attorney? Aren't there, those two things trigger different things, right?
Exactly, they do, yes.
So can you give us like the full Miranda warning, what the difference is if you say I want to be silent or if I want a lawyer, and then also let people know at what point does a police officer have to give you a Miranda warning?
Great, yeah, and leading back to Tan's question too, is that the Miranda warning will start with an umbrella. If you are being investigated for a crime and they come to your house, the officers come to your house with an arrest warrant, they execute that arrest warrant. Now you're in the physical custody, the confines of the police, say it's with handcuffs, you're in the back of a squad car, and there's 2 officers in that car. Now you'd be considered in custody because it's an objective standard. Does a reasonable person believe that they're not free to leave that? I don't think you can leave the squad car, right? You're not going to just be able to walk out with handcuffs locked in the back of the cop car, no. So that's the first prong, right? Now, if the officers aren't talking to you, if they're not trying to engage in an interrogation or any sort of questioning, you need to give Miranda rights because there's no communication taking place. Now, if they're trying to talk to you while they're in the squad car, they're using maybe intimidation, or they're applying pressure in certain ways, or verbally, then they would have to give Miranda warnings. And that is going back to your right to an attorney, and it's really just a warning. It's just a way to let you know that you have these options available. Right. They're not asking you, do you want to talk to me? They're not asking you, do you want an attorney? They're just letting you know you have these options available. Depending on which part of the case you're in, there's Fifth Amendment rights, there's Sixth Amendment rights, for when attorneys can be applied. Part of the warnings is that if you're not able to afford an attorney, one will be provided to you. And that's through, at least in Illinois, called the Public Defender's Office. And they're attorneys that, if an individual is not able to afford payment for a private attorney like myself, and if you're indigent, then they will provide free legal service for you.
Got it. And I would say, or would you recommend as a general rule of thumb, if a police officer is reading you your Miranda rights, you should say, I want a lawyer?
Absolutely,
okay.
Yeah. But I wouldn't even go that far because that might seem a little aggressive. I would just say at first, I would at first just say, I refuse to answer any questions. Respectfully, I decline to answer any questions. Something along those lines. Be cordial, be nice. They're doing their job. And even if they are being a little bit more verbally aggressive, just keep cool, stay calm, keep collected, and you'll be fine. And then ultimately, yes, ask for an attorney later on once you're actually arrested.
Right, okay.
Right. I think to be more specific, case when you mentioned if you're indigent, free service for free. Any other scenarios, any other cases that you can get the attorney for free?
The only time you'd be provided an opportunity for that is if you are formally charged from the officer, from the police station, and you're brought to a judge for, say, the bond hearing. At that moment, and when you're brought to the bond court, then you'll be provided with legal counsel to represent you, to try to fight for you to either prevent a bond from, or to let you, to argue with the judge to say, hey, I think this person deserves to be let out. and they'll come back to future court dates. So then from every moment after that bond court date and every other court date after that is when you'd be provided with a public defender when it's court appointed.
Alright, thanks for your answer. Thì thưa quý vị, cái câu hỏi mà luật sư Mike đặt ra cho luật sư Mark ở đây là cái luật Miranda là gì? Thì Mark trả lời ấy, nghĩa là khi mà bạn bị bắt ấy, thì luật bên cảnh sát ấy, người ta sẽ nói với bạn là những cái gì bạn nói, người ta sẽ cảnh báo trước là những gì bạn nói người ta dùng để chống lại bạn trước tòa, hoặc là bạn có quyền từ chối im lặng và bạn giữ liên lạc với luật sư của riêng bạn. Thì trong trường hợp này ấy, là luật sư Mark khuyên là chúng ta nên giữ im lặng, và tại vì những gì mà chúng ta có thể nói trong lúc hoảng hốt mà những gì chúng ta có nói có thể dùng để mà chống lại chúng ta trong cái phiên tòa nếu như mà điều đấy xảy ra. Thì trong một cái trường hợp mà những trường hợp đặc biệt mà khi mà mình bị bắt mà mình được chính phủ đưa cho một luật sư bào chữa cứu tà mà miễn phí ấy, thì trong những trường hợp đặc biệt đây là bạn là người bản địa này, hoặc là bạn có thể là bị những cái vấn đề trong trường hợp này là bạn sẽ được ủy quyền một luật sư bào chữa cho bạn phiên tòa. Sẽ có ít phút quảng cáo sau khi quay trở lại với chương trình với ba luật sư ngày hôm nay.
Văn phòng luật AGRUSS đã bắt đầu hoạt động từ năm 2012. Kể từ đó, văn phòng chúng tôi đã giúp đỡ hàng ngàn khách hàng với các trường hợp thương tích cũng như giành lại quyền lợi cá nhân cho thân chủ. Thế mạnh chúng tôi tập trung vào tai nạn xe cộ, té ngã, bị ngược đãi trong viện dưỡng lão, bị thú nuôi cắn và sơ suất trong y khoa. Với nhiều năm kinh nghiệm đại diện thành công cho lẽ phải, công ty luật AGRUSS đã giúp quý vị điều chỉnh bảo hiểm, giải quyết chi phí y tế, thiệt hại tài sản và tiền lương, đồng thời theo dõi quá trình điều trị của quý vị để quý vị có thể hoàn toàn chữa bệnh và trở lại cuộc sống bình thường. Quyền của người tiêu dùng giúp quý vị giải quyết được những quấy rối về nợ nần, các cuộc gọi tự động và trở ngại từ thẻ tín dụng. Là người dân, quý vị được hưởng các quyền lợi khác nhau của tiểu bang và liên bang, trong đó có quy định về chi phí luật sư, nghĩa là phía bên kia thanh toán tất cả các chi phí cho công ty luật AGRUSS. Quý vị không cần phải thanh toán bất cứ chi phí nào. Đến với văn phòng luật của chúng tôi, quý vị không những là một khách hàng mà còn là một thành viên trong gia đình AGRUSS, và điều đó giúp chúng tôi cố gắng làm tốt hơn những gì đã đạt được. Chúng tôi luôn lắng nghe và thấu hiểu câu chuyện của từng quý thân chủ để quý vị có thể nhận được về số tiền xứng đáng nhất. Tại AGRUSS, chúng tôi luôn đặt quý thân chủ lên hàng đầu. Công thức độc đáo của văn phòng luật sư AGRUSS đã giúp chúng tôi có được hơn 1.000 đánh giá 5 sao.
Nếu quý vị cần giúp đỡ, xin vui lòng liên lạc với Ngọc. Số điện thoại là 906 9999 773 906 9999.
My name is Mike AGRUSS. I'm the founding attorney of AGRUSS Law Firm. AGRUSS Law Firm started in March of 2012. What I like about personal injury cases is each case is different, so it makes it challenging. It's something new, it's something exciting because you are investigating a whole new set of facts in each case that you work on. What I like most about consumer rights cases is most people don't know about the law. We didn't learn about it much in law school, and if we're not learning about it in law school, most people don't know what their rights are. I enjoy explaining the law to people. It's always refreshing to hear clients say, I didn't know I had those rights, and most importantly, consumer rights cases that we handle, which are primarily financial issues, have what's called a fee shift provision. So my fees are shifted to the other side. In other words, my clients don't pay my fees and costs, the company we're going after does. So it's refreshing to explain someone their rights, you have options, and not only can we fix their problem, the other side has to pay our fees and costs. And the consumer rights practice is like the idea of being able to help everyone in the country. What I like most about representing individuals. I tell people all the time, you're either a plaintiff's lawyer or you're not. From the moment I could walk, I knew I wanted to go to law school, and I always knew I wanted to do plaintiff's work. There was a period of time for about 1.5 years where I did insurance defense work. It was enlightening and I learned a lot, and it makes me a better lawyer on the plaintiff side because I know how the other side is thinking. I'm a plaintiff's lawyer. I like having individual clients. I like having someone to talk to. It's refreshing to get that review from a client. It's refreshing to, it makes me think that this was the reason I went to law school was to help out. My favorite animal is a dog. We have one at home, but I'm a big animal lover. My son is 6 years old and I just got him a fish tank for his birthday, and it's probably as much of a gift for him as it is for me. So I like all sorts of animals, but I'd say my favorite animal is a dog. Most is ways. I feel like I'm thinking, answering questions, analyzing things all day long, going through a million emails, phone calls, and the last thing I want to do when I get in my car is figure out where I'm going. I love being able to plug in an address and Waze tells me where to go. My favorite food is pizza and sushi. I'm a big lover of deep dish pizza, so the original Uno's and Due's in Chicago I've been going to since I was in high school, and I'm also a big seafood fan. I love sushi. When I lived out in California for a couple of years, they had incredible sushi out there. I love it. I miss it. My perfect vacation has always been relaxing on a beach. I've got 2 toddlers at home, and so that's even % relaxing on a beach. Weekends are for catching up on sleep, hanging out with my family, exercising, and most importantly, getting afternoon naps. I'm a and I certainly nap every day. If I was not a lawyer, I don't know what I would be. I knew I wanted to be a lawyer since I could walk. Having started my own firm, I also like the aspect of running a small business, so I would be a small business owner. My favorite book, surprisingly, I don't read much. I would say in high school, my favorite book was Catcher in the Rye. The most recent book I've read that I...
THảNH xin chào quý vị đã quay trở lại với talk show thứ tư ngày hôm nay với tổ hợp luật sư AGRUSS Law Firm, và khách mời ở chương trình ngày hôm nay là anh Mark. Thì tổ hợp luật sư AGRUSS Law Firm chuyên về các vụ tai nạn xe cộ này, tai nạn thương tật cá nhân. Văn phòng luật sư có đặc biệt là có một người đại diện là người Việt Nam, thì quý vị có thể liên lạc gọi trực tiếp đến anh Quý Ngọc qua số điện thoại là 773 906 999, nhắc lại 773 906 9999. Và ok, chúng ta sẽ quay trở lại với chủ đề ngày hôm nay là hỏi về những cái luật hình sự, luật dân sự sẽ như thế nào với sự góp mặt của luật sư Mark ở đây. Alright, so Mark, my next question for you is, what is the purpose of a search warrant?
A search warrant is a tool that an investigative agency can use to circumvent lawfully a Fourth Amendment right to unreasonable searches and seizures. What that means is every person in America has a constitutional right to prevent officers or investigative bodies from walking into your home to start looking around and investigating and trying to find incriminating evidence or your personal belongings or even your own person, the items that you keep. The investigative body to present objective, reasonable evidence to a judge, essentially behind closed doors, and say, the officer is going to come to the judge and say, hey, this is what I found, these are the areas that I want to search. It has to be very specific. The officer has to supply an affidavit supporting what they're saying and what they saw, and they're sharing this with the judge in an attempt to get the judge to say, okay, I agree, I think there's enough evidence here, or reasonable suspicion to supply the affidavit, to supply the officer can go and investigate the area to find whatever they're trying to look for, if it's illegal possession of firearms or drugs, for example.
And to be more specific, what's the process of like the whole thing from submitting that, convince the, hey, this is I'll have to do it. What is that like, and under what circumstance, the type of criminal charge usually?
It could be, the search warrant could be executed really in a matter of see something and they are adamant and about getting the search warrant, and they think that there's time is of the essence, right? They don't have enough time to wait. They can even text judges now, they can email a judge, and they can submit these requests and provide the necessary proof that the officer is seeing to the judge. And there's a judge working 24/7, not the same judge, but assigned judges different days to handle these types of situations. So if it's an emergency, an officer can get a response from a judge within a matter of minutes to have the search warrant executed, and then they can go and search the property or wherever they think that there's a crime being committed.
Thì thưa quý vị, Thành vừa hỏi luật sư Mark ở đây là cái lệnh khám nghĩa là gì? Thì nói về luật pháp ấy, lệnh pháp thì lệnh khám ấy sẽ giúp cho cảnh sát vượt qua cái tố chính thứ tư là Fourth Amendment để mà đến thực hiện cái luật này ấy, bảo vệ cá nhân không khỏi quyền riêng tư, có nghĩa là không cảnh sát nào có thể đến nhà hoặc là đến xe hơi cá nhân của quý vị để mà lục soát đồ. Thì cái search warrant này là cái lệnh khám này ấy, là người cảnh sát sẽ đưa lên tòa án thẩm phán để được sự đồng ý chấp thuận. Và khi mà thẩm phán chấp thuận đấy, thì là trường hợp đặc biệt, những cái trường hợp mà mức độ nghiêm trọng của cái vụ phạm tội này, thì khi mà thẩm phán đồng ý cấp cho cái giấy là ok, mình được quyền lệnh khám search warrant, thì cảnh sát có thể đến trực tiếp và dùng lực để mà khám đồ của quý vị ở trong nhà, ở trong xe chẳng hạn.
I think it'd be helpful about search warrants. Does it ever make sense if someone is pulled over, the cop says, "Hey, do you mind if I search your car?" Would you ever say yes in that situation?
If you know that you don't have anything illegal in your car, absolutely, sure. Let the officer do what they want to do. In legal arguments a lot, and when I'm questioning officers, I do ask all the time, before you search the car, did you have a search warrant? Because the way to circumvent having a search warrant in order to search is if there's exigent circumstances, meaning they've seen something either visibly through a window or in plain sight, or if somebody's running and the officer saw them in possession and then they run into a home. Well, now there's this emergency in place. There's these circumstances that allow the officer to continue pursuing this suspect in the event of preventing further committed, and also just for the general safety of the community. So that's how they can also circumvent a search warrant if they need to.
Got it.
And so I have another personal thing. When I crossed the border from Canada back to the States, and cannabis, and the custom border will basically ask me, "Can I check your back of your car?" Well, I did let him check it, but could I say no in that situation? And what's the consequence?
Absolutely. You could say no. In that scenario, though, now you're facing potential federal charges. So everything we've been talking about so far can apply federally, but my firm practices in state court mostly for criminal proceedings. When you're dealing with crossing state borders or into another country, well, now you're dealing with multiple jurisdictions, you're dealing with federal law, and because marijuana is not federally legalized yet, it's only in individual states that make that determination, that's what's going to cause an issue. So yeah, of course you can say no. It sounds like you're wanting to come back into the United States or you're wanting to go into Canada. So, you could say no, but then they could prevent you from where you want to go. And if they find what you're hoping they don't find, because that will be an illegal transfer of marijuana across, you could be facing some very serious charges.
Yeah. Okay. Thì quý vị vừa đặt ra một cái tình huống ở đây khi mà nói về cái lệnh khám của cảnh sát ấy, thì Thành vừa đặt một câu ví dụ về cá nhân, nghĩa là khi mà Thành đi từ Canada về lại Mỹ, thì một cái người cảnh sát ở biên giới Custom Border đã hỏi là có thể khám cái đằng sau xe hơi của Thành hay không. Thì lúc đấy tất nhiên là Thành trả lời là có, nhưng mà cái mà Thành vừa hỏi luật sư Mark ở đây là trong trường hợp đấy họ không có lệnh khám mà mình không muốn cho họ xét thì sẽ như thế nào. Thì trong những cái trường hợp này ấy, thì mình nên cho cảnh sát xem không mang theo những cái chất cấm hay những cái đồ vật chỉ nguy hiểm, thì mình phải đưa cho cảnh sát xem. Tại vì nếu như mà không đưa ấy, thì họ sẽ gây ra sự nghi ngờ và họ sẽ ngăn chặn cái việc mà mình di chuyển trở lại Mỹ. Trong trường hợp của Thành là họ sẽ không cho bạn di chuyển tiếp và có thể đưa lên sở cảnh sát hay cái gì đấy nghiêm trọng hơn. Rồi.
At AGRUSS Law Firm, we help people who are injured in car accidents. Explain how an at-fault driver could be liable in a civil matter, and how that plays a role into whether they are guilty or not guilty in the criminal case.
Absolutely. So a lot of times our firm represents individuals that were involved, let's say, in a car accident, where the government is stepping in, pressing charges, and they're saying you're at fault because either you were driving under the influence and you caused this injury, or you made an unlawful turn, you didn't use a turn signal, you blew through a red light, and then somebody got injured. The first step typically is to have this criminal matter resolved, to try to get your client to have a not guilty or to have the case dismissed, because then that'll affect potentially the civil case, right? There's different standards of liability though. So in a criminal matter, in order to be found guilty, the government needs to prove beyond a reasonable doubt with evidence and testimony that can convince either a jury or a judge that what happened is beyond a reasonable doubt, that this individual committed that crime. And it's the highest standard in all. Now, as AGRUSS law knows, civil preponderance of the evidence is the other standard, is obviously you have to prove that the claims against the individual, the chances of it actually being committed were 50%, right? So it's a much more lenient, relaxed standard. If you get a guilty in the criminal side, you're going to support potentially the civil case, right? The best example I know of, he was found not guilty in his criminal case, but then when he was brought and faced civil charges for negligence, or if it was the unintentional cause of their death, the individual's death, he was found liable because it's a much more relaxed standard, and then he owed money damages for those claims.
Thank you for explaining that.
Yeah. Before I explain to the audience, can you explain the foundation, like difference between the civil lawsuit and the criminal? What's where the base of the differences?
Yeah, sure. So in the criminals aspect, in the criminal world, it's the government bringing charges against the accused to protect the community, to protect the individuals. It uses these individuals almost as an example to say, if you do this to somebody else, we're sure you're either paying a fine or you're going to go through rehabilitation to preserve the integrity and peace of society, right? So it's more of a societal protection, whereas civilly, it's really just almost one versus one, right? Somebody either breached a contract or they injured just that individual, and the person who's suing the accused is wanting to collect damages to compensate them, to make them whole. If they were involved in this car accident, my client, DUI, guilty, and this person was injured, well, they're going to say, because you were under the influence of alcohol, you were drunk, and you hit my car, you're the reason for my injuries. I had to pay $100,000 in medical bills, so I'm going to come after you now in the civil court, and I'm going to collect that. Hopefully, I'm going to collect those monies from you to compensate myself, to make myself whole, to put myself back where I was before you caused my damages.
Yeah. So, thanks for your answer. Thì thưa quý vị, luật sư Taylor vừa hỏi luật sư Mark ở đây là người bị trách nhiệm trong một cái vụ dân sự, đây là civil lawsuit là dân sự, và không phạm tội trong một cái vụ criminal case, đó là bị hình sự, luật hình sự. Mà cơ bản ở đây ấy, giữa hình sự và dân sự ấy, hình sự là mang một cái tổng quát hơn, khi mà chính quyền chỉ ra rằng cái việc mà bạn làm ảnh hưởng đến một cái cộng đồng thay vì chỉ là một cái cá nhân nhỏ thôi, thì cái tầm ở đây ấy, thì là hình sự sẽ lớn hơn rất nhiều. Còn về civil là dân sự ấy, thì họ thường là những cá nhân và cá nhân thay vì cả một cộng đồng. Khi mà bạn bị người lái xe khi bị say xỉn này, thì đấy là một cái vụ dân sự giữa hai người thôi. Thì người có nhiều trường hợp là bị dân sự mà không bị hình sự, tại vì hình sự mức độ rất là cao. Thường là khi mà chính phủ biết là hoặc là chứng minh được là cái việc bạn làm ấy là ảnh hưởng đến cả một cộng đồng, như là giết người hay gì đấy, thì đấy là một cái vụ mà nặng, mức độ nặng nề hơn, thì dân sự nó sẽ nhẹ nó rất nhiều. Right? My next question is, can police talk to minors, and who needs to be present in that scenario?
That's a great question, and the answer is yes, police can talk to minors. Typically, we see anyone, just us as individuals, we see anyone under 18 being a minor, but under the guise of the law, that's not necessarily true. So to answer your question, if a police officer sees a suspect who's underage, who's a minor, commit an offense, they can treat them almost the same as an adult in the sense that they can arrest them and they can bring them in for questioning. But where the protections come into play to help protect a minor is depending on the severity of the charge. So if you're facing a felony, if it's something that's very serious, then you're considered a minor if you're 16 years old at the time of the offense. If it's a misdemeanor, as simple as just a battery, maybe there is a fist fight and nothing more serious, then you'd be considered a minor at the age of 17. These protections come into play then if you're arrested, because an officer, when they give Miranda warnings, if they're going to interrogate you, right, and if you're in custody, two-pronged test comes into play. The officers have to be more specific. They have to, instead of saying you have a right to an attorney, they have to say, do you want an attorney? They have to say, do you want me to talk to you? Do you want to talk to me? They have to ask specific questions. So that provides more of a protection because they need to ensure understanding what is being said, because mentally they're not as developed as an adult in most cases, right? So their understanding of the law, their ability to withstand the pressure of this law enforcement is going to be much greater than maybe if you were arrested. But that's not always true, right? But it's in place to provide these protections. Additionally, there's specific types of officers, they're called youth officers, that are supposed to be brought in, and they are there to ensure that the interests of the minor are at the utmost importance, and that when they're questioning them, they're following all these guidelines, they're following all these constitutional requirements to protect the minor.
Right. That's a really interesting fact. The police officers, that's the first time I know about it. You have like someone, talking to the minors, not the regular ones.
Exactly.
Protect their interest. Right. Thì quý vị, thì Thành vừa đặt cho luật sư Mark câu hỏi là cảnh sát có thể nói chuyện với trẻ em vị thành niên đây không, và trong cái trường hợp đấy thì ai phải có mặt tại chuyện đấy. Thì trẻ em vị thành niên ấy, nếu như phạm tội ấy, trên 16 tuổi ấy, đều bị xử phạt như một người bình thường, như người lớn, thưa quý vị, là sẽ bị trường hợp nặng ấy là sẽ bị bắt, sẽ bị giam giữ. Trong cái trường hợp mà bị bắt ấy, thì bên sở cảnh sát thì họ sẽ có một người đặc biệt, đó là những cảnh sát viên mà chuyên làm việc với vị thành niên, nghĩa là youth police officers, là họ sẽ biết được là họ đặt những cái lợi ích của người vị thành niên đấy là lên một cái tầm cao hơn, cao nhất so với những người lớn bình thường. Chẳng hạn như là những người cảnh sát đấy sẽ hỏi là bạn có muốn nói chuyện với tôi không, bạn có muốn luật sư hay không, thay vì là những cái câu hỏi, những cái câu tra hỏi bình thường khi mà bạn gặp trong những cái trường hợp với người lớn. Đấy.
What would you, to follow up on that question, what would you advise a minor if a police officer starts questioning them? Like a high school kid on school grounds about something, they're asking some questions because maybe they think someone's got drugs on school property. What would you recommend, or what would you tell the viewers that minors should say if an officer starts asking them questions?
Sure, a good follow-up. And I should have mentioned too that an officer is actually required to make a reasonable attempt to reach the minor's either guardian or parent. So what's considered reasonable is very unclear. Could they attempt to call a parent or guardian and hang them after one ring? It's very unclear what reasonable attempt means. So what I would recommend, and I don't think most minors would, their first instinct would be to contact a lawyer because they probably don't know any. None of their friends are attorneys yet. But their first instinct is probably, oh shoot, I'm in trouble, like I should call my parents. Something's happening, like I should call my parents. So I would always recommend to have the individual and let the parents, either reach out to an attorney, because obviously they have either probably dealt with this, or they know an attorney, or at least they might have an understanding of the next steps. But if they are wise enough and they do have an understanding of it immediately.
If the minor says, I want to talk to my parents, or you should talk to my parents, does the questioning have to stop at that point?
The officer would still then have to make a reasonable attempt to contact the parents, right? But then if they want a lawyer, that's where the protections come into place even greater than just attempting to contact the attorney, the parents, right? Once they say, I want a lawyer, and they're responding to that way, well then communication needs to cease until they are making a phone call to the attorney.
Okay. Let's switch gears to drinking, driving. What should you do if you're pulled over, or if you've had too many drinks, you're pulled over? What do you do in that situation? What do you tell the officer? What do you not tell the officer?
Going back to Taylor's suggestion, if you do have one of my business cards, your protections on the back, and it lets the officer know that you're represented by Mark Galler Law. If you don't have, you're going to have to provide your name and basic information. They're going to ask for your driver's license and proof of insurance. And beyond that, if they're asking, where you're coming from, what are you doing, where are you going, you have, your first instinct should be to I respectfully decline to answer any questions.
Got it. And what would happen in that situation? I mean, I can't imagine, so the cop pulls you over, I'm sure they smell alcohol, and you give them your ID, proof of insurance, and then respectfully decline. I mean, to me that sounds good, but like in practice, what actually happens?
Yeah, and so the way that this is going to work out is that the officer's probably going to get pretty upset. They're probably going to get pretty frustrated. They're probably going to try to apply more verbal pressure to get you to start answering these questions. They're going to say, listen, I'm going to arrest you, I'm going to bring you to the station, there's going to be a lot going on, so if you comply, like maybe I'll help you out, maybe I won't charge you with the DUI. And they try to provide a sense of comfort, or they could potentially try to lull you into responding. Then you start doing these tests, you've been drinking, now you're nervous, you're probably going to fail these tests. Everything's being recorded, hopefully, if they're wearing the body-worn cameras, or if they've got the video footage in their cars. The officers have the squad cars. So you don't want to go down that route, because now you're just giving them too much evidence that they're going to use at trial, and they're still going to charge you with a DUI if they think that there's enough there. And you don't want to go down that route.
And let me ask one follow-up question. Does it ever make sense to do a field sobriety test? Like, let's say you had 2 drinks in an hour. Chances are you're going to be below the legal limit, right? And someone pulls you over. Does it ever, just like you were saying, you're nervous, you're on the street, or you're doing a field sobriety test in the middle of the street as cars are zooming by. Does it ever make sense to do a field sobriety test?
Well, to answer that question, I always say, well, are you a gambling person? Right? If you had absolutely nothing to drink, then sure, comply, right? You have nothing to hide. Give me the breathalyzer test. Let's do this. I will show you I have not been drinking. That'd be my first instinct. I would not try to do field sobriety tests. And I wouldn't suggest to lie, but if you had injuries, or if circumstances are bad outside, the conditions of the weather are pretty severe, I would just say, give me the breathalyzer test. I'll do this right now. I'll show you that I haven't been drinking, rather than trying to do the field sobriety test. That would be my first go-to.
Got it. But if you've at least had 1 drink, it doesn't make sense to do any field sobriety tests, right?
No, especially depending on the strength of the drink.
Okay. That's a lot, Ton. Sorry, but I think it's important stuff, because I think these are things that people run into on the criminal side of things.
Yep, and it creates very nervous and uncertain circumstances that people they don't really know how to handle.
Thì cái câu hỏi mà vừa rồi bạn luật sư Mike hỏi luật sư Mark là khi mà mình lái xe mà mình trước đấy mình đã uống rượu bia rồi đấy, có cồn, thì mà trong cái trường hợp mà bị cảnh sát thổi lại ấy, thì mình sẽ làm gì trong trường hợp đấy? Thì luật sư Mark chỉ ra rằng là trong trường hợp đấy, nếu như mà bạn uống, có quyền là giữ im lặng, là nói với tôi không muốn. Tất nhiên là cảnh sát sẽ muốn cho bạn test một cái bài test là thử nồng độ cồn của bản thân. Bạn có thể từ chối cái bài kiểm tra đấy. Nhưng mà đây có một cái nữa là nếu như bạn có mùi cồn và thật sự là cảnh sát cảm giác được và chứng minh được là bạn đã uống nhiều say rượu từ trước, và những cái hành vi nói chuyện này, cách đi đứng của các bạn, thì cảnh sát vẫn có khả năng là bắt giữ bạn. Nhưng mà cái lời khuyên của luật sư Mark ở đây giữ quyền im lặng và đưa ra cái danh thiếp của luật sư riêng, luật sư cá nhân. Trong trường hợp này bạn có luật sư thì bạn kêu là cảnh sát có thể liên lạc, làm việc trực tiếp với luật sư thay vì nói chuyện với tôi. So follow up on a DUI. Now the other thing that pretty common is texting and driving. What's the law and what are the consequences around that?
The law has changed over the years and is really protecting drivers and saying, listen, if you're going to text and drive, this is going to create trouble for you and your record in terms of having a driver's abstract filled with moving violations. Previously, before legislation was to intensify the severity of texting and driving, it used to be just that you pay a ticket and you move on, and it's not an infraction that's going to be placed on your abstract through the Secretary of State. Mm-hmm. Now it's considered a moving infraction, and that's going to show up on your driver's abstract. If you get 3 moving abstracts in a year, if you get 3 infractions in a year, then you could suspension of your license. So the severity is increased tenfold. Also, if you're texting and driving and you are involved in an accident that creates bodily harm, now you could be facing misdemeanor charges and potentially facing jail time too. So the severity of texting and driving has greatly gone up. I would encourage always to use electronic forms of communication through Bluetooth. Maybe if your car is set up to do voice to text, always do that. Otherwise, you're not going to want to text and drive because that'll cause a lot of trouble for you.
All right. So in the scenario where you absolutely have to take that call and your car doesn't have, wireless Bluetooth microphone, and you actually physically put that, use your hand and another arm like on the steering wheel, and you got into an accident, you cause like body harm to other person. What would happen in that case?
So there's some circumstances where you are allowed to either text and drive or call and drive, call while you're driving, and that's if there's an emergency taking place, right? So maybe you receive a phone call and one of your family members was severely injured, right? That would be your argument to the court to say, well, judge, the reason I was texting or the reason I was on the phone and while I was driving is because there was this emergency situation that I needed to handle. Maybe your child was injured and you're the only guardian or the only parent of that child. Well, that's an emergency. If you cause bodily harm, well, then you're dealing with multiple parties. You're dealing with who is more at fault. Just because it's an emergency, that's going to maybe offset some of the liability. But at the same time, you're still violating that statute. And lawyers come into play. That's where I would argue to say, judge, this call needed to take place because of X, Y, and Z. This is why my client wasn't at fault. Maybe the other driver wasn't paying attention. There's a lot of circumstances that come into play, and that's why a thorough investigation would help in that circumstance. You're also able to text and drive if, let's say, you're stuck at a train, a freight train, and you're at the light and you're going to be there for 10 minutes. You put your car in park, you could text away. If you're stuck at just a stoplight, you can't do that. Right? It has to be, maybe there's a big accident and you can't get around it, then you can start texting and driving and just put your car into park.
Right. You temporarily can't move.
Exactly.
Yeah.
Yes.
For a short amount of time. Then texting is fine.
Yes.
Okay. Yep. Thì quý vị, Thành vừa đặt câu hỏi cho luật sư Mark ở đây là trong cái trường hợp mà mình đã nói nhiều về uống rượu bia này, có ảnh hưởng của cồn khi lái xe, còn một cái tình huống khác là nhắn tin điện thoại khi lái xe. Thì trong trường hợp này ấy, thì có những cái luật xung quanh đấy và những cái hệ quả của việc thì luật sư Mark đã trình bày là text điện thoại khi lái xe ấy, cách đây vài năm ấy, thì nó cũng phạt nhẹ thôi. Quý vị nhắn tin, quý vị bị công an thấy thổi lại thì có thể bị phạt tiền, nhưng mà càng ngày ấy, nó sẽ càng bị nặng hơn. Trong một trường hợp giả sử như bây giờ đi mà quý vị làm 3 lần trong vòng 1 năm ấy, thì quý vị có thể bị tạm, gọi như là cái quý vị bị suspend cái license của quý vị khi mà xảy ra 3 lần liên tiếp trong vòng 1 năm nhắn tin, gọi điện thoại khi lái xe. Và một cái trường hợp mà Thành đặt ra câu hỏi tiếp theo cho luật sư Mark, mình cần trường hợp khẩn cấp như là có người thân gia đình mình gặp cái ở đấy và mình nhất quyết là phải cầm điện thoại lên nói chuyện và mình gây tai nạn, thì trong trường hợp đấy sẽ như thế nào? Thì khi mà cái việc đấy xảy ra thì nó khá là phức tạp. Tất nhiên là mình có thể chứng tỏ được là mình cần phải nghe cuộc điện thoại đấy, nhưng mà cái người mà mình gây ra tai nạn đấy họ lại kêu là cái việc mà mình gọi điện thoại đã cái của cá nhân người kia. Trong trường hợp này ấy, mình cần luật sư sẽ là người vào giải quyết những cái vấn đề cho quý vị và phán quyết là ai là người có tội nặng trong cái vụ nó hơi nhạy cảm như thế này, và luật sư sẽ bảo vệ những cái quyền lợi đặc biệt của quý vị. Right.
Mark, when should someone hire a criminal law attorney like yourself?
As soon as an investigation is taking place, and if you're contacted by somebody from an investigative body, whether it's a detective, whether it's from Department of Child and Family Services, from a school, and they're indicating that some type of violent conduct or activity or illegal activity took place, the next call you're going to make is to an attorney.
So when you're approached with kind of an uncertain circumstance, you want to reach out to an attorney, do you charge for those investigations?
Not for the consultation itself, but what we provide, and me personally, is if I have a potential client that's reached out to me that says, hey, detective so-and-so has reached out and they're starting to question me about some activity that took place last month, and they said to the detective, I want to call an attorney, they call me. What I provide is a service, we consider it a preliminary investigation agreement, where they're not charged with the crime yet, they're being investigated, they know that the detectives have been reaching out, and I'll provide a letter of representation to the individual that says that any governing body, investigative body, before reaching back out to them. But more often, I'm going to be proactive. I'm going to get that detective's name and number. I'm going to contact that detective and let them know, he or she know that I represent this suspect. Any communications must go through me. And then what I do is I help make the transition from investigation to potential, so that my client isn't saying things that they shouldn't be saying. And then that way I help to maybe either ease tensions, prevent things from moving forward so that charges don't even come about. And if they do, then the detective is going to let me know more often than not, hey, your client is being charged. Can you bring to be processed? And I'll help facilitate that so that they're not just showing up at my client's door with an arrest warrant and messing up my client's life and schedule. I can help coordinate that and schedule it so that it's convenient for all parties.
Better to reach out to you sooner rather than later.
Immediately, yes.
Right. Quý vị, thì luật sư Taylor hỏi luật sư Mark là khi nào thì mình liên hệ với luật sư trong một cái vụ hình sự. Thì trong trường hợp này luật sư Mark khuyên là nên càng liên hệ càng sớm càng tốt. Thì khi mà mình có luật sư những người hiểu biết về luật giúp cho mình trong một cái vụ hình sự thì họ sẽ biết được những cái bên nào cần quan trọng. Họ có thể liên hệ với bên sở cảnh sát này, họ có thể lấy những cái bài mà report này, những cái báo cáo này để mà biết rõ là cái hiện trạng của một cái vụ hình sự nằm tới đâu để bảo vệ quý vị quyền lợi một cách tốt nhất. Thì luật sư Mark nói là càng sớm càng tốt, càng sớm thuê luật sư càng tốt. Thì song song với cái việc mà thuê luật sư thì chắc là quý vị cũng đang muốn tìm hiểu về một khía cạnh khác, nghĩa là cái chi phí bao nhiêu khi mình thuê luật sư. Thì đây mình sẽ hỏi luật sư Mark về chi phí thuê luật sư trong một vụ hình sự. So Mark, one of the things that I'm sure that our audience interested in is, associating. So what does it cost to hire a criminal defense attorney?
Well, what I provide to my clients, and the first thing I'm interested in learning about them, is what their financial situation is like. At my firm, I try to make it as reasonable as possible so that we can work together so that it isn't going to financially ruin them. And by that I mean I'm not trying to charge a premium for everything. It's tailored to each case. Mm-hmm. It's tailored to the severity of the charges, what their background looks like if they've got prior convictions, what their familial situation is like, if they've got a job, if they don't have a job. I really try to custom tailor each agreement, client agreement, mm-hmm. to the particular individual. So prices can range, but typically we would require an initial down payment called a retainer fee. That's either anywhere from $500 to half of the overall retainer, and then usually we set up a monthly payment plan. But again, it depends on the client's financial situation.
Mm. Now, with the monthly payment plans, does that mean that you pay like a fixed amount for, let's say this month I have 2 hours consultation, the next month I have maybe triple that, like 6 hours? Would the payment plan stay the same, or it varies based on like how much time you spend, consulting?
Yes, and it depends on the Are we trying to work out a plea deal? Are we trying to prevent my client from going to jail? And we're not focused on focused on fighting the case. That's going to be a fixed amount. If we are going to trial, there's going to be an additional fee for that. Everything's laid out really clean, really nice and legible on a one-page agreement that I go over with the client, and that typically the monthly payment is a fixed amount. And they'll know a range of what the overall fee is going to be. All right, and again, it really depends on the severity of the charges for what that total fee is going to be. So say, for example, for first-time DUI, depending on the courthouse and location, it could be $1,000 or $4,000. So then they pay the initial retainer fee, so maybe it's $1,000, and then from there they'll pay $500, $600, $700 a month until that full amount is paid off.
Right.
And again, it's very flexible.
Flexible, yeah. Thì quý vị, Thành vừa đặt câu hỏi cho luật sư Mark ở đây là cái chi phí mình thuê luật sư nó sẽ tốn kém bao nhiêu. Thì với văn phòng luật sư của Mark Gallagher thì họ sẽ thứ nhất là làm việc với quý vị về cái tình hình tài chính kinh tế của mỗi người. Nếu như quý vị gặp khó khăn này, quý vị bị thất nghiệp hay gì đấy, thì cái giá nó sẽ work out phù hợp với cái hiện trạng hiện tại. Thì thường ấy, về cái cấu trúc mà giá nó sẽ có một cái giá như là mất tầm 5.000 đi, thì quý vị sẽ bỏ vào đấy 1.000 trước, sau đấy trả theo từng tháng payment sau đấy. Thì khi nào mà hoàn thành cái vụ đấy thì thôi. Và thêm một cái nữa là nếu như cái vụ nó phức tạp nghiêm trọng ấy thì cần phải ra tòa này, cần phải tiến hành điều tra nghiên cứu kỹ lưỡng thêm ấy, thì cái khung giá sẽ được bổ sung nữa. Cho nên là cũng tùy vào trường hợp mỗi người, thưa quý vị. Và đây cũng là câu hỏi cuối cùng, Thành cũng muốn hỏi là những luật sư đây có thêm gì lời cuối cùng trước khi kết thúc chương trình. So that was my final questions, Mark. Do you guys have anything to add, to talk to audience, like any advice, when they're dealing with DUI, potential like those kind of legal issues?
Sure.
Advice in general.
Yeah, so at Mark Gallagher Law, I mean, the one thing we really pride ourselves on, and which you can see through client reviews, is our interaction and communication with clients.
Okay.
I'm most of the day answering phone calls, I'm texting, responding to emails, and if I'm not able to fully respond to a question or to a concern, I will let the client know, hey, I'm in court, I'm in a meeting, I'm at VSAM right now doing an interview. I will get back to you as soon as possible, and either it'll be the same day or I'll give them a time frame. So we provide fearless representation with a personal touch, and we're going to fight as fearlessly as we can in court. We're going to do due diligence to collect the evidence, integrity of the case, that when we go to trial, or if we go to a hearing, or if we're dealing with negotiations, we're going to be prepared to get the best outcome for the client. So that's why I recommend to contact an attorney. Hopefully it's me, if it's a criminal defense matter, and we'll respond immediately and really begin fearlessly and aggressively advocating for that individual.
Perfect. Thanks for your answer. Right. Thì thưa quý vị, một trong những cái mà luật sư Mark vừa nói đây là khi mà mình xảy ra cái vụ về hình sự dân sự thì hãy liên lạc ngay lập tức với luật sư. Luật sư là người đứng ra bảo vệ những cái quyền lợi cho quý vị. Những cái vụ mà phức tạp ấy thì họ là những người biết về pháp lý này, biết về những cái mà quá trình nó sẽ như thế nào khi mà đệ đơn rồi bào chữa cho quý vị, thì họ sẽ làm được tất cả những gì mà trong cái tầm khả năng của họ để giúp quý vị thoát ra khỏi cái vụ án đấy. Và đấy lời cuối cùng của chương trình ngày hôm nay, thì mong quý vị hãy theo dõi chương trình show của VSAM1040 trong những cái tập tiếp theo vào tuần sau, thứ Tư nhé.